And on that note, we're going to get started. So this is the blueprint for democracy, which we subtitled How We Can Stop Being Ripped Off. Now, many of us have been very unhappy about what happened with House Bill 6. And in July, former Speaker of the House, Larry Householder, was arrested in what the FBI called Ohio's largest bribery case. Now, before the election, right before the election, the long-term political advisor to Householder, Jeff Longstreth, and lobbyist Juan Cespedes pled guilty to bribery. And today, the FBI raided the chair of the Public Utilities Commission of Ohio's home, Sam Randell. So, what we know is that there are some problems and that we need to make some changes to create greater accountability and transparency. And that's what this is about. So today we're going to be talking about shining a light on dark money. We're going to be talking about strengthening lobbyists and ethics laws next time. We're going to be talking today about discovering who really writes legislation. So this has to do with transparency at the Legislative Service Commission. We're going to be talking about Ohio's whistleblowers law, restructuring the Public Utilities Commission of Ohio, and improving direct democracy. So this is the part one of the Blueprint series. And so I'd like to highlight that when Larry Householder was arrested, U.S. Attorney David DeViller highlighted an obvious problem that created the conditions for the $60 million scheme to establish Householder first as Speaker and then to do the bailout. He said, dark money is the breeding ground for corruption. The State House has not updated the campaign finance law to address Citizens United versus FEC, creating this enormous loophole where we don't have good disclosure of corporate funding of political ads. So clearly that's one area that we need good transparency. Now the Blueprint for Democracy focuses on the ways that we can create accountability and transparency, because the Householder scandal, House Bill 6 scandal, is just a series of scandals that we've had. I think it's important to realize that before Citizens United came along, in 2005, there was the CoinGate scandal. And we've had scandals involving payday lenders, and we've had scandals involving school funding issues. And so when we start to think about the for-profit schools, and you start to think about all the different ways that taxpayers do not have the kind of accountability that we deserve, we need to make some serious changes. And so today we're going to start with Ciara Torres-Spelliscy, who's going to talk about shining a light on dark money. And I'm so pleased that she's with us. She's incredibly accomplished. And so one of the benefits of having Professor Ciara today is she's going to give us a sense of what is going on nationally to help us think about how we should handle this here in Ohio. And so I'm going to go through a little bit about her bio. She is a professor at Stetson University. She is the editor of the 2010 edition of the Brennan Center for Justice at NYU's Campaign Finance Treatise, Writing Reform, a Guide to Drafting State and Local Campaign Finance Reform Laws. She is the author of a book called Corporate Citizen, an Argument for the Separation of Corporation and State. And she has a new book called Political Brands. She is a fellow at the Brennan Center for Justice, a member of the Scholars Strategy Network, and a member of the board of directors of Mertz Gilmore Foundation. And I am so pleased to introduce you. It's going to take a minute, it looks like. We're trying to figure this all out. And we'll have Ciara tell you a little bit about dark money.
All right. So I'm going to
just getting this to go live on Facebook, and it's going to take 1 second, and then I'm going to go back to the presentation in 1 second.
Okay.
All right. I appreciate your patience, everybody.
I guess it takes a little minute. And it should be live in a second.
Well, why don't we take this time for me to review the other folks that are actually going to be with us? So we're also going to have the opportunity to hear from Fed Gittes about how we can improve Ohio's whistleblower law. And then we're going to have the opportunity to hear from Aristotle Hutras. And Aristotle is going to be talking about creating greater transparency at the Legislative Service Commission. And then finally, Elena Nunez is going to talk about how we can improve direct democracy. And I think we all are very aware that there are some significant challenges when it comes to making, going through that process of doing a referendum. And then we also have some challenges when it comes to doing citizen initiatives. And so this wave that was created so that we can hold people accountable has not worked terribly well. And so I'm so glad we're going to hear from her. But first, Professor Ciara, you're up, and thank you.
Thank you. My name is Ciara Torres-Spelliscy, and I'm going to talk about big money in 2020 and dark money in Ohio. Next slide. So the federal election that we just went through was the most expensive in US history. The estimate is that it will cost $14 billion. Next slide. Over $1 billion was spent for the US House. Next slide. Over $1 billion was spent on the US Senate. Next slide. And over $3.5 billion has been spent on the presidential race. This is likely going to be a much larger number because it doesn't account for the last 3 weeks of the election. In 2020, there was more outside spending in the federal election than there had been in any previous election cycle. Next slide. And our political parties were also spending to the hilt with over $4 billion in spending. Next slide. And that's on top of what was happening at the state level. So we didn't have many governor's races up in this cycle, which makes it less expensive than 2018. But it's still $2.7 billion was spent at the state level in 2020. Next slide. And in Ohio, there was at least 82 million spent in Ohio state elections alone. Next slide. And I think probably one of the reasons why I'm speaking to you tonight is I wrote a piece for the Brennan Center on the bribery scandal in Ohio and how it showed the dangers of dark money. When you have dark money, it can hide all sorts of things, including criminal behavior. Next slide. Now, when I talk about dark money, I have been talking about this topic for about a decade at this point, but I should explain what it means and how it works. So if you have a corporation that doesn't have the courage of its own convictions and wants to spend in politics, but it wants to hide its role, then all it needs to do is give to an opaque nonprofit. Typically, these are 501c4s, which are social welfare organizations, or 501c6s, which are trade associations. And once, go back. Once that corporate money is in that opaque nonprofit, it's the nonprofit that spends in politics to support or oppose candidates. And what the public can see is that the nonprofit was spending. What the public can't see is that a corporate spender was the original source of the nonprofit's money. Okay, go ahead. And one of the things that has been very difficult for the campaign finance system to get its hands around is what exactly has to be disclosed. And that turns on what is a regulable political ad. So between Buckley versus Vallejo, which is 1976, and 2002, which was when the Bipartisan Campaign Reform Act was passed by Congress, the only ads that could be regulated from a campaign finance disclosure point of view were ads that contained express advocacy. These are also known as the magic words from Buckley. Next slide. And an example of the magic words from Buckley is something I borrowed from The Simpsons, and it's just an ad that says, "Vote Quimby." And the magic word there is vote. And so if Quimby was a candidate for office, then this is a regulable ad under express advocacy. Next slide. But this left a huge gaping loophole known as the sham issue ad loophole, because if you avoided those magic words, you could avoid disclosure. And so in 2002, in the Bipartisan Campaign Reform Act, otherwise known as McCain-Feingold or BICRA, a new definition was added to federal law, which is the Federal Electioneering Communications definition. And so if you have an ad that's a broadcast ad, which airs 60 days out before a general election or 30 days before a primary, reaches 50,000 people and costs $10,000, those ads can be regulated under federal campaign finance law. Next slide. And the Ohio definition of electioneering communications largely tracks the federal definition, but it's more narrow because it covers less time. So instead of covering 60 days out from a general election, the Ohio law only covers 30 days. One of the improvements you might make is expanding that to 60 days because we know that that's constitutional according to the Supreme Court. Next slide. So with an electioneering communication, these are ads that avoid vote or support those magic words from Buckley, but they nonetheless attack a candidate for office. And so I think of these as the Bob is the devil ads. Next slide. Now, on paper, it would seem like the Ohio campaign finance laws were doing the things that you would want campaign finance disclosure laws to do. It requires disclosure of contributions to candidates. It requires disclosure for people who are making independent expenditures. Next slide. And next slide. It also seemingly requires the disclosure of people who are giving to electioneering communications. But this is on paper. My good friends at Ohio Common Cause inform me that this is not the way this law is being enforced. So another improvement that you could make to your laws is to enforce the laws as they are actually written, because you don't actually have the worst laws in the nation. Next slide. So here are some suggestions for how to improve your laws in Ohio. One of the things you could do is have disclosures on a more regular basis. One of the things that people who are trying to avoid disclosure do is they will have their ads run at times where it either doesn't trigger disclosure or doesn't trigger immediate disclosure. So you could tighten up that part of the law. Another thing you can do is have better disclaimers on political ads themselves. And for example, in California, they require top donors to the ad to be listed in the ad. And that is an improvement of disclosure to the end user and to voters. Next slide. And so another thing you could do is capture super PAC spending that is directed at Ohio. And you could do more regulation of individuals who are doing petitions in Ohio, including better disclosure for the employers of the people who are spending money. And then finally, giving your Secretary of State or others in your enforcement agencies subpoena power would improve the enforcement of campaign finance laws. Next slide. So the good news is I am sure that Ohio can fix this. Next slide. But you've got to do better than this. If Householder can be reelected, given all that he is facing, something is not working at a very basic level. Next slide. So thank you, and I look forward to our discussion together. Thank you.
Well, I don't know about the rest of the Ohioans, but I felt a little salt in the wound there. Thank you very much, Professor Ciara. Yeah, I think it was really hard for me when I realized that Larry Householder was reelected, even though uncontested and there were write-ins. It was also hard when one of the whistleblowers was not reelected. And so one of the things that, that makes this really difficult and this conversation so important is that we need to identify some ways to create transparency and accountability. So I have some questions that folks have shared. So the first question is, are there states where you feel are good examples or good models for Ohio?
So California, which I mentioned, does no one has a perfect system, in part because if you have someone who is hell-bent on hiding their role in politics, there are just sort of a number of things that they can do. Sometimes this is known as the daisy chain problem or the Russian doll problem. This was before Russia was a big issue in our elections. What I mean by Russian doll problem is you give money to one entity that gives to another, that gives to another, that gives to another. I'm not actually talking about Russia for once. And when people spend in that way, even if you have a really transparent system, it just becomes this system of whack-a-mole where it's very difficult for someone to trace. But the problem with dark money is once it goes through one of those opaque nonprofits, the 501c4s or the 501c6s, no amount of due diligence will allow a voter to find out where this money really came from. And that's the problem that we have to solve, whether it's federally with Congress and the FEC or in Ohio at the state level.
So one of the things that our governor has questioned and other folks have wondered about has to do with the constitutionality of disclosure. Could you walk people through, what's constitutional, what's not when it comes to disclosure?
So the good news is every time that the Supreme Court has gotten its hands on disclosure in the past decade or so, they have actually upheld it. So for example, Citizens United has two holdings. One is the famous one that corporations can spend an unlimited amount on political ads in any American election. But the second holding is just as important. It says that the disclosure of the sources of money in politics is perfectly constitutional. And the Supreme Court has not overruled that part of Citizens United. And I think even with this new complement of justices on the Supreme Court, they are unlikely to have the 5 votes that they would need to get rid of the constitutionality of disclosure.
So the next question that I have has to do with the frequency of filing. So one of the things that you identified was, hey, maybe there should be more frequent filings. And so like, if a state is considering that, like what's reasonable, what's not reasonable, how do folks navigate what's reasonable?
So the Supreme Court has been pretty good about high frequency filing, especially close to an election. That was upheld in McConnell in a 2003 Supreme Court decision. One of the things you might want to be careful of is what is sometimes known as first dollar disclosure. So if you have a really low threshold for disclosure, courts have been a little bit more allergic to that, because what they worry about is that the campaign finance disclosure regime becomes a trap for the unwary. So you spend $1 on, one thing, and suddenly you have to report. So think about your reporting thresholds. You're trying to catch the whales, not the minnows. And another thing to think about is building a legislative record that shows the types of political spending you have in Ohio, because a court is inevitably going to review whatever improved disclosure laws you have. And so litigators are going to have to explain to a judge, why did you pick these thresholds, or why did you pick these reporting timelines? And so make sure that you have a strong legislative record, so it's easier for a court that's reviewing the law to uphold it as constitutional.
So I have one more question, which has to do with like the political advertisements. And so, we can all think about the political advertisements that we see, and the names are like Americans for Apple Pie, or I don't know, Ohioans for cake. And so one of the reforms that you mentioned had to do with adding kind of additional information. Can you tell us a little bit about that?
Sure. So sometimes we think about this as top donor disclaimers. Disclaimers are the pieces of text or spoken words that are at the very end of most political ads. So, I'm John McCain and I approve this message, or that's a federally required disclaimer. And so instead of just saying, I'm candidate X and I supported this message, you would say, and this was funded by, my two favorite Koch brothers, or whatever it was. And that extra disclaimer gives the voter much more information. And so when the Supreme Court has upheld campaign finance disclosures, one of the things that they have said is that there is a voter informational interest that is served by campaign finance disclosures. And so I think that a strong disclaimer requirement would also survive constitutional muster, even at this Supreme Court.
Well, and it's interesting to think about, a Generation Now ads having, Generation Now ads and having the top donor as First Energy. Being able to not just connect the dots, but really know who's funding for the ads would make a real difference for us. Mm-hmm. Well, Professor Ciara, thank you so much. Now, I'm going to remind everybody that we're going to have an opportunity to have a discussion on December 7th. And then I'm sure I did not get to everybody's questions. They're coming in fast and furious from a couple different places. And so what I'll make sure to do is make sure that we have an opportunity to kind of go through questions during that discussion period. And then I'm going to also go through and look to see what the questions are, and I'll try to put together a piece that answers some of the questions. So now our next batter up is Fred Gittes. Now Fred is with the Gittes Law Group, and he is a former president of the National Employment Lawyers Association and the Ohio Association for Justice. He was appointed the chair of the Civil Rights Committee for the Ohio State Bar Association for 5 years. He was elected chairperson of the Ohio State Bar Association's Labor and Employment Law section. Now, this one I think is interesting too about Fred. In 1996, Fred's firm became the first law firm ever presented with the ACLU of Ohio's statewide award for contributions to the preservation of civil rights and civil liberties. Fred's firm has also been awarded the Columbus Urban League's Award for Excellence and the NAACP of Columbus's President's Award and Environmental Achievement. And with that, I'm handing it off to you, Fred. And thank you.
I guess I better unmute. I have prepared 2 pages of bullet points about the Ohio Whistleblowers Law. And I did that, I hope, in a way that'll make it obvious to you. Actually, some things, oh, I see, someone's modified this. Why, unlike the professor who said Ohio's campaign disclosure laws aren't the worst, we have, in my opinion, the worst whistleblower law at the state level in America. I could not possibly, if you can scroll if you want after people get a chance to look at the first page to the second page. I couldn't possibly cover every one of these points in the less than 10 minutes I now have since I already started talking. I want to talk about why these laws are so critical to democracy and open government in every sense of the word. We have a whistleblower's law. We had it passed, and of course, you hear from judges and you hear from political people, well, we already did it. But just like we've seen in the last election, where people are told, well, you have the right to vote. But when you get into the details of whether you can vote, when you can vote, what you have to do to vote, how you have to sign your name, how many envelopes do you have to use to mail in your ballot, it may change whether there really is an actual right to vote for a lot of people. There's a lot, I'm really glad that Catherine talked about the scandals, going back to CoinGate decades ago at this point, and talking about the householder associated scandals with energy. But what I would say to people, and why I care about this law, and I was involved way back when it was first enacted, is that what you should worry about is all the scandals you don't know about, because there are far, far, far more illegal actions, graft, fraud than are ever reported. And the reason you know about many of these, not all of them, some of it's just good investigative law enforcement work, but a lot of them, I would say most of them that you do know about are because of whistleblowers, because the incredibly brave individuals whose livelihood is put at stake who is willing to report the graft, the fraud, the criminal misconduct, which can take many forms, the discrimination, the racism, the violence in the workplace, and the list goes on. I can tell you that because of the way the state law in Ohio is written, many people who come and talk to me leave feeling they can't risk exposing it. And that has been magnified in recent years because of the internet. When I started practicing law, I could represent someone to file a lawsuit against their employer, or who blew the whistle, or sued about discrimination. And in many cases, they could find jobs because jobs were available, unlike now, obviously, but also because there was no internet. The ability to search court records and to do searches to find out whether you have a reporter who's a candidate, someone who actually tells the truth, wasn't easy. Now I have to advise every person who comes to my office, you must understand, if you file a lawsuit or you take anything that's going to become public as an action against the person you work for or the institution you work for, everybody's going to know. It's likely, even if it's not, doesn't hit news, public news reports in professional media, it's going to be on the internet through social media. So with that background, and keeping in mind most whistleblowers are individuals who have families, may be at a key point in their career, because that's why they have access to information. And they are working most often in very large and powerful institutions. Keep that in mind as you look through these sheets. Now let's go back to the first sheet. I'm just going to highlight a few things and Catherine will tell me when to shut up. If you look at what's called the protected categories, when you look at whistleblower laws, what do you want to look at? First, there's three categories I've put down here. What does it cover? Now, I'm going to highlight a few, but just look through it. First of all, misdemeanors aren't covered by our whistleblower law. And by the way, I'm mainly talking about the private sector whistleblower, but much of what I'm going to talk about also applies to the separate law covering public employees. I just don't have time to do both. But if you're working at a big, large corporate entity that you know is overcharging people, but in an amount that doesn't reach felony levels, maybe it's a few $100s for each little transaction, or they're committing fraud, which is de minimis, or they're misrepresenting things. So there's a host of things they could be doing. A whistleblower could report it, and they would not be protected in Ohio at all. If you look down, look at the bullet point about professional ethics. Many organizations have set professional ethics. Many corporate entities, I'm sure many people on this call have worked at a corporation that had business ethics. Well, under this law, even if the business has it, or depending on the profession, whether it's medical, legal, or otherwise, and you have a lawyer working in it, and they report another lawyer's professional ethics, it wouldn't be covered under the statute. What about obeying an illegal order? You're ordered to do something illegal. It's not covered. You're protected if you report it, and we'll get to how in a minute, but refusing to do it, by the way, is not illegal. If you go down a little more, and I'll stop on this section because I know I'm going to run out of time here. If you show testimony, I'm sorry, go back to that page. What if you testify? Let's say you go to a hearing on unemployment where the employer claims they fired somebody for a good reason, and you're an employee working in this institution, and you testify truthfully that no, they didn't do that, or they did their work. You're not protected in Ohio. Same for a workers' comp case. If the employer claims they didn't injure themselves at work, and the employee comes in and testifies, well, yeah, they did, I saw it, and they're fired the next day, they are not protected. And most employers and employees do not belong to a union. They're not public employees. They have no protection for being fired under the employment at will doctrine. Even reporting things to prosecutors, even crimes, misdemeanors, even felonies. If you don't follow the procedure, which in my opinion is ridiculous in this law and is just a trap for unaware employees, you can still be fired. And I'll explain that more if we go to the next topic. Now, no, one more. Go down further, I'm sorry. Okay. Well, we're not into the spot I said, but in order to make a report, that how you actually have to use the statute is very cumbersome and purposely made so. One, it's not if you pick up the phone and call a prosecutor because you believe there's a crime going on, and then you report it verbally to your employer, you're not protected. If you report it to your employer and you pick up the phone and call the prosecutor, but you don't put it in writing first, you're still not protected. And if you do report it and you do put it in writing and you don't wait 24 hours to determine if your employer made a reasonable effort to fix it, you're still not protected. And what is a reasonable amount of time? How do you decide how long you have to wait or whether they're being reasonable? It's just clearly, I can give you case after case examples of absurd situations where people were fired. Okay, I have 1 minute. Well, let me finish by focusing on what is the most important thing. If you're going to be a whistleblower and the public wants you to at least take the risk involved, and there's always going to be risk because you may report it and you don't win your case. This law only allows you to recover back pay and attorney's fees. or you may lose your whole career. You may never be able to get another job because this is all going to be public, and most employers are going to say, hands off, they're a troublemaker. So I have a list here of all the things that are unavailable under our law, which would be economic damages besides back wages, for all the loss of a career, future loss stages maybe is already available. The fear, the stress, the anxiety, the worry about your family and education of your kids, all that people go through in these situations. The damage to your reputation, because you know what? They're going to accuse you of everything they possibly can, they know of, and what they'll make up during a trial or when they're trying to attack your report. None of this is protected under our act. So when you ask, well, why don't people report it? I always ask everybody, knowing this, would you, if you have a family, can you afford to? Do you? And it shouldn't be this way. And I'll stop with that.
Well, Brennan, thank you so much. And I'm going to ask you a few questions that we have received. I think the first one is, people have talked a lot about Tyler Furman and his stepping forward. And also the surprise that nobody from First Energy has been a whistleblower. And you walked us through a little bit, but as you look at the difference, I'm just kind of interested in the difference between the protections that are related to politics and public officials and the ones that are related to private businesses. Can you tell us just a little bit of the difference and what you would do to improve it for each of those?
Well, what I would do to improve it for both of those is broaden the coverage. If you look the first part of my list, my bullet list, people should be able to testify and be protected. People should be able to refuse to obey an order and be protected. These are common sense things. They should be able to report ethics violations. They should be able to report everything on that list, most of which are not covered. Secondly, you have to have a reporting mechanism that encourages them to believe they have a reasonable opportunity of keeping their jobs, or at least a sufficient remedy to help their family survive. So the first of that is you shouldn't have to write a written report and make a verbal statement and wait 24 hours. Why is that necessary? If it's a serious problem, it's not going to be fixed in 24 hours. And if there are authorities whose responsibility it is to deal with it, whether it's a crime or a governmental regulation violation that the AG can deal with, or the IG, the Inspector General of Ohio, in the public setting, or other situations. And public employees, by the way, have a little more room to report directly without talking to a supervisor and writing it first. But that should be true across the board. And then there shouldn't be any question about, if it's proven that they were fired, transferred, harassed, which is not covered by the current statute. What happens to a lot of whistleblowers, they may not fire them outright, but they make life so miserable for them, they feel compelled to quit. They need to have the list of remedies that I have under unavailable. All of those things. They should be allowed to transfer away from bad actors who are harassing them, supervisors. They shouldn't have to put up with it anymore. It should be their choice. And then the last thing I want to mention, which is the last of the unavailable, I cannot stress this enough. It goes back to the Civil War and Abraham Lincoln, qui tam. If there were a state qui tam program, a lot of these industries, and I don't know actually off the top of my head, but First Energy may have been covered by a qui tam statute because of the financial support they get from the state. You need to allow, they are whistleblowers. It's just a fancy name for an individual who reports fraud by companies that are getting public money. There is a federal qui tam provision that has recovered billions and billions of dollars in federal monies that have been lost. There is no qui tam law in Ohio. It's been introduced on a number of occasions and went nowhere. We all know why that's the case, because major corporate entities that contract with the state of Ohio, that get funding from the state of Ohio by grants or any other means, if they are misstating, misleading, or falsely claiming they fulfilled a contract when they didn't, they would be exposed. And qui tam allows the reporter to recover a reward for exposing it. It's big money that leads to these frauds and these ripoffs. And somebody who exposes it at risk to themselves, they can't have participated in it. They cannot be a qui tam reporter if they did. They should be put in a position where even if they can't get another job, they'll be okay.
So I think then I have one kind of final question. Someone wondered about kind of the differences between federal and state, and just like you've identified the things that we could do to change the law, but it's our federal whistleblower law is better than state. Can you tell us a little bit about that?
Well, overall, every anti-retaliation law I know, and almost every federal whistleblower is better than Ohio's, because Ohio's is just terrible. But the federal law, the problem with the federal whistleblower law is it only relates to federal activities and federal contractors. There are a lot of what we're talking about, and I'm focusing on now, has nothing to do with the federal government. And so they don't apply. There are really good retaliation. Whistleblower is a kind of a specific kind of anti-retaliation law. So let's take the case of discrimination. If a woman is sexually harassed and she reports it, either in an investigation at the company or to the Civil Rights Commission, or even reports harassment of one of her co-workers, and she is fired or demoted or denied a promotion, all of that is covered. But it's only for discrimination situations. The whistleblower statute tries to cover everything else. So we have a handful of statutes in Ohio, like nurses, for example, are protected to report health endangerment of patients, and they're protected with full remedies. But for most of the kinds of things that go on in these workplaces, and especially dealing with fraud and economic offenses or cheating people, whether you're a small business, medium business, or a giant business, there are unscrupulous business people like there are unscrupulous people in every trade. And it doesn't apply to a lot of them. So you need to plug all of these gaping holes in the law.
Well, on that, it sounds like we have our work ahead of us to address the whistleblower law. So I'm going to throw in a poll into this as we move over to hearing from Aristotle Hutras. What we really wanted to do is have a sense of how you all are engaging in democracy. And so there's a note here that says that I can't vote, which kind of annoys me. But for the rest of you, you should just let us know, like, how are you participating in our democracy? What kind of civic activities are you participating in? And then once we get a few of you in there, what we'll do is we'll show you the poll, and then we'll move on to hearing from Aristotle Hutras, who's going to talk about the need for greater transparency so that we can actually discover who is actually writing Ohio legislation. Now, Mia put in the chat just to highlight that you'll notice that you likely participate in more than one of these activities. So mark as many as actually fit, and then we'll get our poll results in just a minute or two. We'll do one more poll towards the end as well. And let's see, we're at 55% of you voting right now. And since, the state of Ohio did a little bit better than that, in November, we're at 70%. Are you ready to pull the lever? Okay, let's see what we got. 724 people. Okay, let's see. Mia, what's the result? Oh, 100% of us vote. I'm glad to see that. People have registered voters. I signed a ballot measures way up there. Oh, and 9% of us have run for office. This one is so high. 73% of us have canvassed, phone banked, or text banked. Thank you so much. And 90% of us have contacted our state or federal lawmakers. And of course, that is going to be essential as we come up with an agenda for how to create greater transparency. All right, well, Mia, if you're willing to put up the slide for Aristotle, I'm going to introduce him. Now, I have known Ari for years. He's like me. I've been around the State House for a while. As I was thinking about all the different ideas and things that I've discussed with Aristotle, he is just the right person to talk about, well, what is it actually, what's actually going on at the State House, and when did we start to have less transparency when it comes to the legislative making? So Aristotle Hutras is the founder of the Aristotle Group and the former longest serving executive director of the Ohio Retirement Study Council. And on that, Ari, I'm going to hand it off to you. And thank you.
Well, thank you. I have to take a minute here to introduce the father of democracy. Elena probably recognizes Cleisthenes. The Athenians who invented direct democracy. Now, as Catherine said, I've been around the State House for a lot of years. Started out as a page and ended up being the executive secretary of the House. Now, this problem, specifically, the biggest, I think, disclosure prior to this one was 2 decades ago with Roy Ray, senator from Akron, who essentially had written a bill as a consultant for Ohio Edison. So the process of, and obviously it escalated because I think his consulting fee was, I don't know, 120-some thousand bucks or 150,000 bucks. But I mean, we've seen this escalate to $60 million. Now, I have worked with the LSC. They're good people. I've worked with legislators over the years. They're good people. There's always a few bad apples. And I don't think anybody is suggesting that people should be prohibited from helping to write legislation. That is a given. If it's the people's house, everybody has an opportunity to sit down. I've sat down with legislators in a public office, to talk over, draft a legislation. I've sat with LSC in the same room. And those things are important. It's always been called the people's house for a reason. And we all learned in school how a bill becomes a law. 7th grader Missy Ripple thinks that the state bird should be the cardinal, writes a letter to a legislator, they pick up on it, they have a committee meeting, they introduce a bill. And I tell you what troubles me the most is because I love the place, I love the process. And I really have a lot of respect for the people in it. And I think this episode, the reason people don't vote is this is one of the reasons. They don't believe that their voice matters. Their voice should matter whether you're drafting legislation, whether you're going to the polls. Now, as somebody who has spent a lot of time around the State House, I thought it would be prudent if I read you a few paragraphs from the House Journal, Monday, January 7th, 2019. We have to always remember that the people of Ohio have given this building to all of us as a tool. And how we use this tool is of our own choice. We can use this tool to tear apart, or we can use this tool to separate, or we can use this tool as others have before us to build. I also think that it's important that the House of Representatives open itself up. And one of the things that I'm going to advocate for are the TV cameras in all those committee rooms to be turned on. There are so many people in the state of Ohio who, for whatever reason, can't get here to see their government operate in action and in person. And switching those TV cameras on and giving the opportunity for those people to see the work that we do in these committees, I think we're going to go a long way to try to open the doors of our State House. Secondly, I'm a firm believer that we table too many amendments in committee. Those opportunities are how each and every single one of you members of the legislature, can better represent your folks back home. Accessibility, openness, the ability for them to sit at home and watch what each one of us does do every single day, I think are all ways that we can be even better for the people of Ohio than we already are today. Now that was part of the speech that Larry Householder gave when he was elected Speaker of the House. Now that pains me. So I think our job with respect to opening up the LSC, turning the lights back on with dark money is going to be easier than we thought. If I were a legislator sitting in the chamber, this would have been a challenge to do all those things for the very people that sent them there. And I've worked in the State House. I took an oath to the state of Ohio, to the United States of America. I was a tenant. I mean, I just worked in that place. And I think a lot of people have lost sight of that. I mean, nobody can stay forever. And it's an opportunity to really get the people engaged again. There's nothing to hide when you're talking to LSC, you know, unless you should be hiding it. But why would you be talking to the Legislative Service Commission? And like I say, it kind of it saddens me because I've been around and I see how hard people work, and I see how when people come to committee and testify, they're there a lot of times for help. And I think to forget what your job is when you're there and not to speak truth to power is just a major disservice. And like I say, I take it really personal. I love the place. And I want to be helpful in turning the lights on and having the LSC do their good work, and the press, the fourth estate, has every right to get in there. And one of the things I'd like to see happen is that Jim Siegel, who worked for the Columbus Dispatch, wrote the last article a decade ago about no more secret legislation. And I think the Jim Siegel amendment is something that I would introduce in a lame duck session, to do the things that Larry Householder challenged the body to do. So those are my 2 cents.
Well, thank you. So, you know, for folks that are familiar with I'm only a bill, yes, I'm only a bill, and they're used to like thinking of the process as, you know, hey, we first of all, it's, you know, it's introduced by the sponsor and then it works through committee. So I think the thing that that I want to be sure that that people understand, and we've had a question about this. So the Legislative Service Commission are the lawyers for the lawmakers. Why does it matter that we don't get access to those records?
Well, I mean, they're working on public policy, so why shouldn't the public be involved in public policy? I mean, it's not, now if you want to do something, you're running a corporation and you bring your corporate people in and say, hey, we're going to be closed on Sunday from now on. I really don't care. But and a lot of the folks at LSC, hey, not everybody's a lawyer. You know, when I was the executive secretary of the House, part of my job was to hire interns, you know, college folks that had an interest in government. And, you know, the LSC helps you codify your idea. And they also, you know, help you whether or not it's going to be constitutional or unconstitutional. You know, they don't set policy. The LSC says, Catherine, what do you want to do? And you tell them, and they go, well, okay, here's how you do that. Here's the code section it fits in. You know, here's what it's connected to. That's what they do. You know, it's a really necessary. If Jefferson said that the states are the laboratories of democracy, then it ought to be wide open to everybody. I mean, you can go down to committee and testify. Shouldn't you be able to testify on a bill with everything in it? It's bad for the process. It's bad for the people because that's why they don't participate. They don't think that what they say or what they do makes any difference, and that's just wrong.
So I had an interesting question, and here it is. Are lobbyists to blame for this lack of transparency? Do they want to keep it secret?
I think that legislators know they shouldn't keep it secret. You know, and like I said, there's no problem with a lobbyist sitting down with Representative Jones and saying, hey, you know, I got a client. We would like, you know, Section 141 change to do this. There's no problem. There's no, you know, in the legislative process, and you all know this, there's no executive session. You know, you don't go, hey, time out, you know, hey, we're going to talk about this and nobody will know what we're talking about. It's a transparent process for good reason. So no, that's, you know, I think legislators should just say, no, we're not doing that.
So this is the other question. So does this reform mean that we would understand who is responsible for amendments in like a substitute bill?
You mean a person?
Like who asked for, you know how like sometimes what happens as opposed to having individual amendments, there's a substitute bill. But if you created a more transparency at the Legislative Service Commission, would we, the citizens of Ohio, be able to track who is responsible for each amendment?
Well, I do think that we could deliberate about that, because I just said that if, Cindy Jones wants the state bird to be a cardinal, a legislator would stand up and say, Cindy Jones, 7th grader from contacted my office. Now, I don't think we need to, slow the entire process down. So there's a press conference every day. It's just, if the press, the fourth estate goes in, and says, hey, I understand, in this example, First Energy was in your office. That, and allegedly, I'm not saying they got to tell everybody what they talked about on that day. We can't, I don't think we can be absurd about this, because now
is that they become public records.
Yeah, just public record, what it always was. It's not, because the minute you get absurd, then they go, well, see, we'll never fix this because now you're being absurd. No, I just want it to amend that section, take the language out, and the LSC, the press could call and just say, hey, that's the way it used to be. I don't think it was
a little late on the legislative process. Ari, thank you so much for walking us through this. And so our next batter up is Elena Nunez. Now, Elena's with Common Cause, and she is the Director of State Operations and Ballot Measure Strategies for Common Cause. Now, Elena serves on the Board of Directors of the Ballot Initiative Strategy Center, and is on the Circle of Advisors for the National Vote at Home Institute. Now, she's originally from Arizona, and she's now living in Colorado. And I'm always pleased to work with her, and I'm hoping she can give us a little bit, walk us through ways we could improve direct democracy right here in Ohio. And thank you, Elena.
Thanks, Catherine, and thank you everyone for joining us tonight. It's really been a fascinating conversation for me as someone who's done legislative work in Colorado, to just hear all of the ways that Colorado and Ohio are similar, and also ways that maybe we can learn from each other. So I want to talk a little bit about the initiative process and how we can use direct democracy to strengthen public participation and engagement in our states. So first, I'm going to start with some good news. You can see on the screen with a rather faded but really happy map. And the map is showing you victories that we've had at the ballot in 2018 and 2020. And what I think is really exciting about it is all of those dots that you see, and we'll send it around afterwards so you can dig into it, represent measures where the people were able to stand up and advance democracy. So you'll see there's a star for Ohio that includes the redistricting reform. A few other states that have passed in the last several years include Virginia, Michigan, Colorado, and Utah. And what I think is striking about that is if you look at those states, they don't have a lot in common. They're red, they're blue, they're purple, all different parts of the country. But redistricting reform is something where the people agreed that fair maps were important. And because we had the right to take the issue to the ballot, we were able to advance reforms. And so I think it's a really inspirational and important touchstone as we talk about ways to strengthen it, to realize that as a state that has this process, Ohio's already ahead of the game. And that's for a couple of reasons. And I think they're obvious, but I always just want to say them. The first is that when you have the right to take issues directly to the ballot, that allows you to address issues where the legislature won't. And sometimes that's because there's a conflict of interest. So I think redistricting is a good example of that, where oftentimes the legislature needs a little bit of a nudge. It also includes things like reducing the influence of money in politics or strengthening ethics laws. And if you look at the different measures that have passed over the last several years, I think we've seen that whether the threat of the initiative process is used to incentivize a referral or the people go straight to the ballot themselves, that's been an important tool. So it's just something to keep in mind that it's a real strength that we have. And even though it's challenging, it gives us a lot more opportunity for reform. So let's go to the next slide. So when we look at the ballot process, I think there are several places where we see efforts to make the process more difficult and to block public participation. And I realize it sounds funny to say block public participation because fundamentally the initiative process, direct democracy, is about the people. But what we often see is that legislators, often at the behest of special interests, are looking for ways to make it as difficult as possible to move reform forward. And we see that at every step. So the first step in the process is what I would consider the policy stage. And the way that that comes together traditionally is a group of people have an idea, maybe something slightly more complex than Cindy and her state bird, and they say, we want to move a ballot measure to address an issue. And oftentimes it's a measure that maybe was a bill at the legislature and couldn't get a hearing or couldn't get out of committee. Or maybe it's something where we've seen it several times come up and it's just never quite had enough momentum to become a law, or where there's really entrenched opposition at the legislature. Whatever it is, we the people come together, draft a policy. Now, here's one place where I'll flag that I think Ohio is a little unusual, and that is that the ballot question, the setting of the question that goes before voters, doesn't happen at this stage. And that's a little unusual. And I think it makes it difficult and is actually a burden for voters, because when they're considering a measure, they don't have the full benefit of knowing what they're going to see on their ballot. So that's one place where I would just flag. I think Ohio, that's an opportunity to create better transparency for voters. Then we get to the qualification phase. And this is one where we have to demonstrate that there is enough support to move a measure forward. And, you know, I am a big believer in the initiative process. I think direct democracy is incredibly important. I also think it's fair that if you're going to put a question before the voters of a state, you have to demonstrate that there's enough interest to take that question up. But I think what we've seen, and this came up in 2018 in Ohio, there's often a desire from the legislature, or again, outside interests, to try to make the price of entry for qualifying ballot measures so high that only the most powerful interests can qualify. So in Ohio, if you want to move forward with a ballot measure and you're amending the state constitution, you need to collect 10% of the number of signatures for someone who ran for governor. So 10% of the gubernatorial votes determines that. And then if it's a referendum, it's 6%. Now, this is where the interplay of the number of signatures you need and the amount of time you have can be a real barrier. So for a veto referendum, you only have 90 days, and that's an incredibly short period of time. It's not atypical. A lot of states have this 90-day clock, but when you think about it, the people, and again, you all had this experience just recently, the people are coming up against an issue at the legislature that's highly contentious. They disagree with the way the legislature went. They want to put it to a vote. In order to have that conversation, you're looking at more than 250,000 signatures just to put that question before the voters. And you have to collect it in an incredibly short period of time and from voters throughout the state. And I think that's an open question. You know, should you have to demonstrate statewide support? Like, you should to pass a measure. I mean, that's why you need 50% plus one. You have to show the people are with you. But these requirements make it really difficult. And so it means that if there are laws that aren't popular, there are often groups who aren't able to then challenge those measures because they just don't have the resources to support a signature gathering operation to do that. So I think that's, again, where, as I'm thinking about ways that we make it difficult to really take advantage of the promise of direct democracy, both the number of signatures as well as the amount of time you have can play a real burden, as well as do you need to gather them statewide, where if you have a requirement that you need to be in every county, that can often serve as a barrier as well. Then, assuming you get through all of those barriers, and that's not an insignificant process, takes a lot of time, takes a lot of money, takes a lot of supporters, volunteers, as well as oftentimes paid staff, you then get to the portion of the campaign where you actually have to make your case. And this is one where I think there are a lot of opportunities for Ohio to strengthen the information that we give to voters, specifically around campaign finance. And I think, and this goes back to the first presentation we heard from Professor Ciara, but in order to be informed voters, we need to know who's trying to influence our vote. And that's true for candidates. It's also true for ballot measures. And in Ohio, you have a pretty lax reporting schedule. You have 4 reporting cycles over the course of the year. And because they're so broad, so there's one reporting period that goes from June through 20 days before the election, it's possible you could see a lot of money come in and not really know where it's coming from until almost the end of the campaign. Or the next reporting period, which is the post-election report, we don't find out until December who was working to influence our votes during those final couple of weeks. So again, it creates a barrier to understanding who's behind a measure. And I think when we think about the ballot process, really it's us coming together to act as citizen legislators. And part of being a citizen legislator is having the information to make an informed decision. And sometimes we know, sometimes everybody knows, XYZ corporation or such and such interest group is behind a measure. But sometimes you don't know. And when you look it up, what you see on the billboard is, Ohioans for Ohio. And then this gets to the second area where I think there's room for improvement, and that is making user-friendly filings, so that if you see that and you remember it's Ohioans for Ohio and you look it up, you can actually see who's contributing to that campaign. And I think there's a couple of things we can do here. One, in Colorado, my home state now, if you go to the Secretary of State's website, on the page where they show you the text of a ballot measure, they also tell you the committees that are supporting and opposing it. So at that moment, you can look and see who's for and against. But that only gets you so far. You still have to show where is the money coming from for those committees. I did a quick search this afternoon and just looked up a couple of committees in Ohio, and I found one that had hundreds of thousands of dollars coming in, and some of it was in kind from an organization, I didn't know who they were, and some of it was paid out for legal services. So there was no way to see what they were actually spending money on or where it was coming from. And then finally, on the campaign finance side, and this is another idea that Professor Ciara mentioned during the Q&A, there's also the move towards top contributors, so that if you get a flyer from, Yes on 12 or whatever it is, it shows you here are the 5 entities who have put in the most money towards this campaign, so you can evaluate who's really behind it. And I think that's another way that we can use transparency around campaign finance funding to help people make better decisions about ballot measures. Then finally, we get to the vote. And I just want to flag 2 things that I think are threats that have come up, not only in Ohio, but throughout the country. And the first is requiring a supermajority vote to pass a constitutional amendment. So in Florida, you need 60% if you want to change the Constitution, which makes it harder, of course. And that also tends to make it more expensive. You need to run more significant campaigns in order to persuade more voters. And so it puts people at a disadvantage who are trying to run proactive measures. And then the other way that we see attacks on the process is saying that you need to approve a measure over multiple elections. And this is something that happens in Nevada, where if you pass a measure, in order to take effect, it has to be on the ballot a second time, which again, makes a much more expensive campaign, a much more complicated campaign. And all of these things don't make the process stronger. What they do is they make it more difficult for people to participate in meaningful ways. Let's go to the next slide. So to close, I just want to flag that I think that the threat is that we often see when there are popular measures that there is a backlash. And I don't need to tell you all, there was the House Joint Resolution 19 back in 2018 that would have made the initiative process much more difficult. And doing that by reducing the time you can gather signatures, as well as requiring a supermajority for passage. And I think we'll continue to see threats like that, because as long as we can demonstrate that the initiative process is being used to move strong reforms, or we see veto referendums attempting to show that we can check legislative power, there will always be that push-pull. But I think the opportunity is that this does give us a chance to make our case directly to voters. And with some of the reforms we just talked about in terms of more transparency, as well as opening up the process, there are also ways, I think, that we can make it a tool that is more accessible not just for those who can afford to run multi-million-dollar campaigns. With that, I will open it up for your questions. Oh, and then last, yeah, some resources, places to go if you want to learn more about some of the measures that have been on the ballot, as well as the democracy landscape and the initiative landscape overall.
All right, well, I'm going to ask you a couple different questions. So during the House Bill 6 referendum, there were a couple different challenges that occurred. One had to do with the kind of 90-day window. So like it's, you know, we have 90 days from the time that the bill is officially signed by the governor. And yet there's a whole process for getting certified for the ballot. So, you know, organizations, the groups that wanted to referendum House Bill 6 were really behind the 8 ball because that time was eaten up, you know, the time was just eaten up and it was very hard to get going. So they had significantly less, you know, significantly fewer days. And so one, I wondered if that was the case in other states and if it's the kind of reform that you've seen that makes a difference when it comes to referenduming.
Yeah, and I think those are great questions, and I think there's two pieces to it. And I think the first is that it's not that common to see referenda succeed. There are some, like we've seen some measures. I know of a few that qualified this year, despite the pandemic, and you know we're on the ballot. But it's a pretty high bar because in a lot of places you do have that 90-day clock, and that clock combined with high signature thresholds means that oftentimes you need to have a pretty well-funded operation ready to go the moment your opportunity to collect starts in order to have a successful petition effort. And I think it's just important to recognize that that is a trade-off, that by setting that bar so high, it really does make it difficult for grassroots groups to be able to use the referendum tool effectively. And I do think that's by design. I mean, even more so than the initiative initiated process for a statute or a constitutional amendment, a referendum is an attempt to directly overturn the legislature's actions. And so I don't think it's surprising that you see that tension in play. So I do think, it would be useful to have more time. And also I think to think carefully about how do you demonstrate enough support in such a short window, whether it's 90 days or slightly more, so that people still have an opportunity to use the process successfully. Because I do think the barrier right now is just so high that even an organized group, once you start cutting into the appeal, like the process that pushes out those time, you don't have the full 90 days, it's hard.
So we have had issues with doing citizen initiatives where if the ballot board is friendly to you, you get really good language. And if they're less friendly to you, I'm going back to 2012, which is always a little painful. We got our butts really, really kicked. But the language, when the ballot board liked a redistricting reform measure, they were 4 bullet points. When they didn't like it, it was 3 pages, meaning it just went on and on and on, and mentioned that it was taxpayer funded multiple times. And so one of the things I've been trying to figure out is like, well, how could you address that problem? How can we make it for a more accountable ballot board?
Yeah, I mean, I think there's a few different things to look at. I mean, part of it is who's on the board. And that's certainly something where having, clear expectations for who's sitting on the board and some expectation that there are standards that they will be following is important. I think there are things that can be built in around specific criteria. So for example, is there a requirement to use plain language to the best of their, ability, or avoid catchphrases or things like that. And I think the other question is that decision reviewable? So if a proponent gets a 3-page summary back and says this does not accurately reflect it, do you have the ability to then challenge it and get a better result? And is that something that is used and done? And again, that depends on the politics of a state and how it all works. But I think those are the sorts of pieces that could change it. But I think as much as possible, having standards for, this is the question voters are going to see, whether the ballot board loves your question or hates your question, you shouldn't be able to tell reading the question. And that's, having a set of standards around, is it descriptive? Is it accurate? Is it factual? And more specificity about how you can decide, like, do you always say taxpayer funded? And if it's requires, any appropriation, is there a fiscal analysis that, voters have to see? Some states have that. And, again, that's something that can play both ways, but just being really clear that it's not about, do you have the votes on the ballot board? Because if you had the votes on the ballot board, you might have the votes of the legislature. I mean, it's, again, how does this actually function as an independent check?
So we're in the middle of a pandemic, and we got a question that had to do with, like, were there states, like we were a state that it was determined that we could not collect signatures electronically. Are there states that have been able to do that?
This was a very hot issue this year. And it was something that there was a lot of litigation about and a lot of states trying to figure out. And for the most part, states followed Ohio's lead, or, fell in the same place as Ohio where it wasn't allowed. I do think that there is a question now that because we have technology, through the use of, in many states, it could be your online voter registration system, a way for people to express their support. I think that it's something that could be more open. But we did see a lot of creativity, during the pandemic. For example, in Oregon, our Oregon organization was part of a redistricting measure where they mailed petitions out to folks and said, sign it and send it back to us. So that's an option. I think a lot of states are looking at, what does electronic signature gathering look like in the future and what could it look like? There are a couple of jurisdictions in Colorado that have started experimenting with being able to collect signatures on tablets, which doesn't eliminate the need for an in-person interaction, but it does allow you to do real-time verification. So you can tell if the person's registered, and if they're not, they can go to the voter registration page and complete that. So it increases validity. So I think it's going to be a hot topic over the next several years of what is the right way to do that, and do we have to change other requirements to kind of keep up with that?
Well, during House Bill 6, some of the signature gatherers were really harassed in a way that was pretty unpleasant. And in fact, it turned out that people that were just trying to register voters were harassed because they were mistaken as people collecting signatures. And so one of the things we've been talking about and wondering about has to do with a buffer zone, or are there other kinds of reforms that you've heard about or people have been talking about?
Yeah, and it's really hard because when you have bad actors who use, something like intimidating people from signing, I think our natural reaction is to say we shouldn't do that. We need to create, free space for people to be able to engage. And I think that's right. At the same time, when there are measures that are really devastating, we often see groups organize decline to sign campaigns, which, shouldn't be physically, threatening or intimidating, but are also trying to provide a counterpoint and saying, hey, those folks over there that are telling you that this is, going to cut your taxes, they're not telling you it's going to come at the cost of our schools or whatever. So I think it's a really hard question, because every reform, you have to look at it from both how does it help us when we're trying to advance a measure, and how would it hurt us when we're opposing a measure? But I do think it creates a question of how do we create space so that people do feel safe, whether it's going to vote, where we saw intimidation outside of our polling places this year, or signing a petition. How do we create a space that does feel safe, that gives people the chance to engage without completely closing off to free speech? So I think my answer is no, I don't have a great solution, but I think that is it's a real problem. And I don't think there's an easy answer.
Well, I want to say thank you to Elena, and I also want to say thank you so much to the panelists today to give us the opportunity to think through some different ideas, to consider, what should we do about dark money, or what should we do about the Legislative Service Commission? How can we encourage people to be whistleblowers, and what is it that we can do so that our direct democracy functions better, because it's such an important check. Now, we're going to have some additional session next Monday at 7 p.m. And at that session, we're going to talk about the Public Utilities Commission and maybe restructuring it. And we're also going to be talking about some ethics and lobbyist reforms that will improve, could improve the system. And so I'm really glad that we're going to do that. I'm going to ask Mia if you'll throw in a poll right now. We are on December 7th going to have discussion of all these different topics. And so what I'm hoping for is that you pick 2 or 3 topics that are the most attractive to you. And when we get to December 7, those are the topics that we're going to dive right into. So you have options from shining a light on dark money, improving Ohio's whistleblower law, discovering who really writes Ohio's law, improving direct democracy. Now, I know we haven't heard from restructuring the PUCO and about lobbyist and ethics laws, but they may be really interesting. And we're gonna, we'll be doing this poll in other locations as well, so that we can identify the best ones to take a really deep dive into it. So I don't know how this is coming. How many people have participated? We got to 70% last time, so I'm going to encourage you to keep at it. And I once again want to really thank everybody. We have hit 827, and I appreciate everybody thinking about, what could we do? It's not enough just to wring our hands and know that Ohio has a corruption problem. We do need to actually get somewhere. We need to get somewhere and make changes so that we get the kind of government that we actually deserve. And so I don't know if you noticed that Mia was prodding you along, and we're at 75%. I'm ready to find out which ones are the winner, Mia. There we go. Oh, all right, we have a winner. Ciara, Professor Ciara, I bet you're pleased to see that a shining a light on dark money gets 75% of the vote. Ooh, look at this, 57% of the vote goes to improving direct democracy. The next batter up is discovering who really writes Ohio's laws. And then we have strengthening lobbyist and ethics laws. So let's keep at it. And I hope that I'm going to see you all and at our next session, which is on November 23rd at 7 p.m. For those of you that were like, hey, I want to see the slides, we will be mailing them to you. For those of you who are interested in getting a recording, we'll send that out to you as well. And I just really wanted to thank all the people that made this successful. So once again, thank you to our panelists for providing us some good wisdom and helping us kind of think through what our next steps are. And everybody on your calendars, our second session is a week from today. So 7 p.m. next Monday. And thank you all. Be well, take good care of yourself, and think about democracy. Thank you, bye.